Priscilla Vane step away from the trust account
This
files?
is an accounting or reconciliation issue, not a crime.
The ILA balance is short against pending client obligations.
You were looking at timing differences.
Priscilla Vane operated without meaningful oversight for 3 years as a licensed attorney in Halloway County, New Hampshire. 11 clients trusted her with their settlement funds. Not one person checked. She would not talk her way out of this.
The settlement funds, leases, and disbursements do not...
11 clients owed money the account did not
That is not how trust accounting works, and I am not letting you misread.
Within 72 hours, forensic accountants working for the New Hampshire Bar had pulled every deposit and every wire from her interest on lawyer's trust account going back 4 years. 11 clients, $640,000. A shortfall that could not be explained by anything except the truth. And the truth was that Priscilla Vane, an attorney of 18 years, had been quietly draining the settlement money of injured people who had trusted her with it. Before we go any further, I have to ask, have you ever handed money over to a professional and just assumed it was safe because of the license on their wall? Drop a comment below and let me know. And if you're new here, subscribe. We cover these cases every week, and the ones involving lawyers are always the hardest to shake. Priscilla Ann Vane was born in Manchester, New Hampshire in October of 1975. Her father was a residential appraiser for a regional insurance carrier. Her mother taught 5th grade at a public elementary school on the west side of the city. The family lived in a modest colonial on a quiet street lined with maples and the kind of neighbors who noticed when a lawn was left uncut. There was no drama in her childhood, no trauma to point to. Neighbors, later interviewed by a local reporter after her name appeared in the disciplinary docket, described the Vane household as almost aggressively unremarkable. Sunday dinners at 4, report cards on the refrigerator, a Buick Century that her father washed every other Saturday. She was a serious child. Her 5th grade teacher would later describe her, in a quote given to the union leader, as the kind of student who read the assigned book and then asked for the next one. She graduated near the top of her class at Manchester Central High School in 1994. The yearbook listed her as a member of Model United Nations, the debate team, and the Honor Society. Her senior quote referenced the Fourth Amendment. Her classmates voted her most likely to argue a case before the Supreme Court. She enrolled at the University of New Hampshire in Durham that fall, majoring in political science with a minor in economics. She worked part-time as a filing clerk at a small Portsmouth law firm during her sophomore and junior years, earning $9 an hour and, according to a partner at the firm who was interviewed years later, developing what he called an unusual patience for the tedium of civil procedure. She graduated magna cum laude in 1998 and enrolled that same fall at what was then called the Franklin Pierce Law Center in Concord, now the University of New Hampshire Franklin Pierce School of Law. She was on the moot court team. She wrote a note for the Law Review on the fiduciary obligations of trustees under the Uniform Trust Code, an essay that would take on a bitter symmetry 23 years later. She passed the New Hampshire bar exam on her first attempt in July of 2001. Her mother framed the bar admission certificate and hung it in the front hallway of the Manchester house next to a photograph of Priscilla at 9 years old, holding a fishing rod on Lake Winnipesaukee. For the first 4 years of her legal career, she worked as an associate at a mid-sized firm in Concord that handled a mix of insurance defense and municipal litigation. Her evaluations described her as diligent, thorough, and possessed of a sharp instinct for settlement value. She was on partnership track. She was engaged, then married to Douglas Vane, a dentist who had opened a family practice in the small town of Halloway Falls in Halloway County, about 40 minutes northwest of Concord. In 2007, at the age of 31, she made a decision that would define the rest of her life. She left the Concord firm, moved to Halloway Falls to be closer to her husband's practice, and opened her own solo shop above a hardware store on Main Street. She called it Vane Law Office. The sign was hand-painted on a wooden board by a local craftsman. The office had 2 rooms, a small waiting area with 2 upholstered chairs, and a window that looked out over the town's Civil War memorial. She built the practice slowly. Personal injury cases from local car accidents, small business disputes, the occasional will. She was known for returning phone calls promptly and for taking on cases that larger firms would have declined for lack of profit. In a small county like Halloway, this reputation compounded quickly. By 2015, she had 2 children, a 5-bedroom colonial on a hill overlooking the Contoocook River Valley, and a caseload that kept her at the office until 7 most evenings. She served 2 terms on the County Bar Association's Ethics Committee. She was invited to speak at continuing legal education seminars on the proper handling of client funds. She was, by every visible measure, exactly the kind of small-town attorney the New Hampshire legal community held up as a model. That was the version of Priscilla Vane her clients knew. It was the version they trusted with checks that represented the entirety of their financial recovery from the worst days of their lives. To understand what she did, you have to understand what an IOLTA account is and why the legal profession created it in the first place. IOLTA stands for Interest on Lawyer's Trust Account. Every state bar in the country requires attorneys who hold client funds, whether settlement money, retainers not yet earned, or escrowed sums awaiting distribution, to keep those funds in a separate, regulated account. That account cannot be commingled with the attorney's operating money. It cannot be used to pay office rent. It cannot be used to buy a car. It exists solely to hold what belongs to the client, until the moment the client is entitled to receive it. The rules governing IOLTA accounts in New Hampshire are among the strictest in the country. Attorneys must maintain contemporaneous records of every deposit and every disbursement. They must reconcile the account monthly. They must be able, at any moment, to identify exactly which dollar in the account belongs to which client and for what purpose. The state bar can audit the account without notice. Deficiencies are reported to the Attorney Discipline Office. Misappropriation is grounds for immediate suspension and, in most cases, permanent disbarment. The system exists because the legal profession, over more than a century of hard experience, understood something uncomfortable about itself. Attorneys occupy a unique position of trust. Clients hand them money in moments of vulnerability. Sometimes that money represents everything the client has recovered from an injury, an accident, a wrongful death. The temptation and the opportunity to divert that money is significant. The regulatory architecture around IOLTA accounts is the profession's attempt to prevent its members from becoming the very thing their clients fear most. The New Hampshire Bar also maintains something called the Public Protection Fund. Every practicing attorney in the state contributes to it. Its purpose is to reimburse clients who have been victimized by attorney misappropriation. The existence of the fund is itself an acknowledgement that no regulatory system, however tight, can prevent every case. The fund exists because these cases happen, because the profession knows from its own history that they will keep happening. Priscilla Vane knew all of this. She taught it. She sat on the committee that enforced it. When she opened her IOLTA account at Halloway Savings Bank in 2007, she signed a document acknowledging her fiduciary obligations under the New Hampshire Rules of Professional Conduct, specifically Rule 1.15, which governs the safekeeping of client property. The structural weakness of her practice was not in the rules. It was in the size of the firm. She had no partners. She had one part-time paralegal, a woman named Linda Farnsworth, who worked 3 days a week and handled filing, phone calls, and appointment scheduling. Linda did not have signature authority on the trust account. Linda did not review the reconciliations. Linda did not see the bank statements. Priscilla did all of it herself. She received the settlement checks. She deposited them into the IOLTA. She calculated the fees and the case expenses. She prepared the settlement statements for the clients. She wrote the disbursement checks. She signed them. She mailed them. There was no second set of eyes on any of it. There was no independent administrator. There was no partner asking questions. The system that was supposed to protect her clients depended in the end on her honesty. And starting sometime in the early spring of 2021, that dependency began to fail. The first diversion, as far as the forensic accountants would later be able to establish, occurred on March 11th, 2021. A client named, for the purposes of this narration, Robert Chenard had settled a rear-end collision case with a commercial trucking insurance carrier for $118,000. The check arrived at Vane Law Office on March 4th. She deposited it into the IOLTA the same day. The client's share, after her 1/3 contingency fee and documented medical liens, was approximately $62,000. Under normal practice, that $62,000 should have been wired to Chenard within 10 to 14 business days. It was not. On March 11, Priscilla Vane transferred $42,000 from the IOLTA to her firm's operating account. She used the money to cover a quarterly estimated tax payment, an overdue commercial lease payment on the office space, and a $5,000 deposit toward a family vacation in the Bahamas. When Chenard called 2 weeks later asking about the disbursement, she told him the insurance carrier had flagged the settlement for a routine tax withholding compliance review. She told him it would be resolved in 30 days. She apologized for the delay. There was no compliance review. She had invented it. 28 days later, another settlement arrived at the office. A wrongful termination case for a woman named, again for this narration, Diane Palmieri. $94,000. Palmieri's share, after fees and costs, was $58,000. Priscilla used $42,000 of Palmieri's settlement to pay Chenard. That was the moment the scheme became a scheme. Forensic accountants call this pattern trust account rotation, or more colloquially, lawyer kiting. It works exactly like check kiting, and it fails for exactly the same reason. Each new settlement deposit is used to cover the disbursement obligation to the client whose money was diverted previously. The trust account never actually holds what it is supposed to hold, but as long as new settlements continue to arrive, the shortage can be papered over. The problem is that the shortage grows. Every time a new client's funds are used to pay off an older obligation, the amount owed to the newer client is now short. To pay the newer client, another settlement must be diverted, and another, and another. Priscilla Vane operated this rotation for nearly 3 years. The fabricated explanations became a small library of ready-made delays, insurance carrier processing complications, tax withholding compliance review, remaining lien negotiations with the hospital, Medicare secondary payer verification pending, structured settlement documentation still being drafted. Each phrase was plausible enough to buy 30 days. Some bought 60. When clients pressed harder, she moved to written explanations, printed on Vane Law Office letterhead, with just enough legal jargon to survive a phone call to a friend who worked in insurance. The money did not go anywhere spectacular. It is one of the strangest details of this case, and one of the most common. There was no yacht. There was no second house in Costa Rica. There was no gambling addiction, no cocaine habit, no secret family in another state. The diverted funds paid for the ordinary expenses of a life that had been quietly outrunning its income for years. Her husband's dental practice, once profitable, had contracted during the pandemic. 2 of his hygienists had left and not been replaced. The couple's 5-bedroom colonial carried a mortgage that had been refinanced twice. Their older child, Ethan, was enrolled at a private preparatory school in Concord that cost $38,000 a year. Their younger child, Claire, was showing horses on a competitive circuit that ran from Vermont to Virginia. There was a boat at a marina on Lake Sunapee. There was a landscaping service. There was a housekeeper who came twice a week. The lifestyle had been built on the assumption that the practice would keep growing. When it did not, when the local car accident caseload flattened after 2020, the household did not contract. It borrowed, first from credit lines, then from a home equity loan. Then, when those were exhausted, from the money her clients had entrusted to her. By the summer of 2023, the shortfall in the IOLTA had crossed $400,000. By the summer of 2024, it was approaching $600,000. The rotation was becoming harder to sustain. Some clients had waited 8 months, 9 months, 10 months. The excuses were wearing thin. The letters were getting longer. The phone calls were being returned less quickly. She knew, at some level, she probably could not admit even to herself that it was going to end. She just did not know how or when, or who would finally be the one to stop believing her. Her name was Margaret Doiron. Everybody in Halloway Falls called her Peggy. Peggy Doiron was 57 years old. She had worked as a lunch aide at the elementary school for 23 years. She lived in a small ranch house on the outskirts of town that she had inherited from her mother. She drove a 14-year-old Subaru Outback with a bumper sticker for the local library. In October of 2023, she was rear-ended at a stoplight on Route 202 by a delivery van that had failed to brake. The impact drove her Subaru into the vehicle in front of her. She suffered a fractured sternum, 3 cracked ribs, and a herniated disc in her lower back that would eventually require surgical fusion. She hired Priscilla Vane on the recommendation of a co-worker whose son had used the firm for a workers' compensation case. The case settled in April of 2024 for $285,000. After Vane's 1/3 contingency fee, documented medical liens, and case expenses, Peggy Doiron's share was approximately $152,000. She needed that money. She had been unable to work since the accident. Her short-term disability had run out in February. Her savings had been drained by the deductibles and co-pays for the surgery. She had refinanced her mother's house to pay for physical therapy that her insurance had partially declined. She was told the disbursement would be issued within 2 weeks. 2 weeks passed. Nothing. She called. She was told that the insurance carrier had flagged the settlement for a compliance review. She was told to expect resolution within 30 days. 30 days passed. Nothing. She called again. This time she was told that there was a Medicare secondary payer issue that needed to be resolved because of the age of her medical bills. She did not entirely understand the explanation. She trusted her attorney to handle it. 60 days passed. 90 days. 120. By the end of August, Peggy Doiron had missed 2 mortgage payments on the refinanced house. Her physical therapy had been suspended because she could no longer afford the out-of-pocket portion. She had begun borrowing money from her older sister, who lived in Nashua and did not have much to spare. Every time she called Vane Law Office, she got Linda Farnsworth, the paralegal, who would apologize and promise to have Priscilla call her back. Sometimes Priscilla did. The explanations shifted. Sometimes it was the lien negotiation. Sometimes it was a subrogation issue. Sometimes it was structured settlement paperwork. Peggy wrote them all down in a notebook she kept next to her landline. By September, she had a list of 7 different explanations, 3 of which contradicted each other. She was a lunch aide at an elementary school. She was not a lawyer. She was not a financial professional. But she had raised 3 sons and buried a husband, and she knew when someone was lying to her. On September 11, 2024, 9 months to the day after the settlement had funded, Peggy Doiron drove to a computer in the reference room of the Halloway Falls Public Library. She searched for how to file a complaint against an attorney in New Hampshire. She wrote down the address for the attorney discipline office in Concord on the back of a library envelope. That night, at her kitchen table, she wrote out a 5-page handwritten complaint. She attached copies of the settlement agreement, her notes from every phone call, and the printed letters Priscilla had sent her with the shifting explanations. She mailed it on September 12th. The complaint arrived at the attorney discipline office on September 16th. It was routed to a senior disciplinary counsel named Christian Wexler. Wexler had been with the office for 11 years. He had seen hundreds of complaints, and he had developed an instinct for the ones that mattered. Most complaints were fee disputes, communication problems, disappointed clients whose cases had gone badly. Those got resolved through informal processes. The Doiron complaint was different. The letters attached to it, purporting to explain the delay, cited insurance industry procedures and regulatory processes that Wexler knew from 11 years of reading attorney correspondence, did not exist in the form Vane had described. He picked up the phone and called the bar's Public Protection Fund administrator, a woman named Ellen Prevost. "I think we need to look at her trust account, right now. We are about to get into the forensic review, and it is the part of these cases that most people never actually see happen. If you appreciate this kind of detailed accountability coverage, subscribe and hit the bell. There is a specific shape to how attorney trust account fraud gets uncovered, and the next few minutes walk through it start to finish. An emergency review of an attorney's trust account is not a routine audit. It is a specific procedure invoked by the New Hampshire Bar when there is credible reason to believe that a fiduciary breach may be ongoing. It requires the signature of the chair of the Attorney Discipline Office. It authorizes the bar's forensic accountants to obtain bank records without the target attorney's knowledge or consent. Christian Wexler had that signature by the end of business on September 19, 2024. By September 23rd, forensic accountant David Ashburner was working through 3 years of statements from the Halloway Savings Bank IOLTA account bearing Priscilla Vane's name. The math was not complicated. Ashburner cross-referenced every deposit against the underlying settlement documentation Vane's firm had filed with the court in each personal injury case. He tracked every wire out of the account against the disbursement records the firm had produced to clients. He constructed a running balance of what the account should have held at any given moment against what it actually held. The gap was catastrophic. As of September 1, 2024, Vane was obligated to hold approximately $812,000 in the IOLTA on behalf of 11 clients whose settlements had funded but not yet been disbursed in full. The actual balance in the account on that date was $172,000. The shortfall was $640,000. There is no legitimate way for a trust account to hold less than the sum of pending client obligations. The account, by definition, cannot dip below that number. If it does, the only possible explanation is that funds belonging to clients have been used for something other than the client's purpose. The math was the case. The math could not be argued with. The math did not require testimony or corroboration or a cooperating witness. It was, in Ashburner's word from his eventual affidavit, structurally dispositive. The forensic team then reconstructed the rotation. They identified every point at which incoming settlement funds had been used to disperse to an earlier client. They mapped the diversion transfers into Vane's operating account. They traced the operating account outflows into the personal expenses: the Bahamas trip, the Concord prep school tuition, the horse trailer purchased in April of 2023, the $18,000 down payment on a new Volvo XC90 in August, the landscaping, the housekeeper, the 2 mortgage payments made in cash from the operating account after the home equity line was frozen. None of it was extravagant in the way that word usually gets used in these cases. There was no yacht. There was no penthouse. It was just the steady bleeding out of $640,000 into the ordinary maintenance of a life that had run out of its own money. By October 4th, Wexler had a memorandum ready for the Attorney General's office. The New Hampshire Attorney General has jurisdiction over criminal referrals from the bar. The AG's office assigned the case to an Assistant Attorney General named Nathan Trombley, who specialized in financial crimes and professional misconduct prosecutions. Trombley had the file, the forensic reconstruction, the client complaints, because by now several other Vane clients had come forward, and the letters signed on Vane Law Office letterhead containing fabricated explanations. Those letters were, from a criminal standpoint, the wire fraud counts. Each one had been sent through interstate mail or generated by email. Each one constituted a use of a wire in furtherance of a scheme to defraud. By late October, the case had also been referred to the United States Attorney's Office for the District of New Hampshire. Federal wire fraud charges would parallel the state theft by misapplication charges. The investigation moved quickly after that. It moved quickly because the evidence was, in effect, one document. On the morning of November 14, 2024, Christian Wexler placed a phone call to Priscilla Vane's office. He asked her to appear at the Attorney Discipline Office in Concord for what he described as a formal interview regarding a complaint filed against her firm. He did not tell her which complaint. He did not tell her about the emergency review. He did not tell her that the AAG's office had already begun drafting the indictment. She agreed to come. She agreed to come the following morning. She did not bring an attorney. That was, from her subsequent perspective, the last mistake in a long series of them. She arrived at the Attorney Discipline Office at 9:30 in the morning on November 15th, 2024. She was wearing a navy blazer over a cream blouse, dark slacks, and low-heeled shoes. She was carrying a leather briefcase and a paper cup of coffee. She was shown into a small conference room on the 3rd floor. Christian Wexler was there. So was Ellen Prevost, the Public Protection Fund administrator. So was David Ashburner, the forensic accountant, with a laptop open in front of him. She did not know who Ashburner was. Wexler asked her to sit down. He told her the interview was being recorded. He informed her of her right to have counsel present. He asked if she wished to proceed without counsel. She said yes. Wexler began with the Dwiron complaint. He walked her through Peggy's timeline. He asked her to explain each of the delays. Vane's explanations in the interview transcript were fluent at first. She used the language she had used with Peggy on the phone: compliance review, lien negotiation, structured settlement documentation. Wexler let her finish. Then he opened a folder in front of him and slid across the table a single spreadsheet. Ashburner's reconstruction of her IOLTA account. Ms. Vane, as of September 1st of this year, you were obligated to hold $812,000 in trust for 11 clients. Your account held $172,000. Can you help me understand where the other $640,000 is? There was, according to the transcript, a pause of 11 seconds. I don't have that information in front of me. We have the information in front of you. I am asking you where the money is. Another pause. Shorter. I would like to consult with counsel. Wexler nodded. He told her the interview was concluded. He informed her that a formal notice of disciplinary proceedings would be delivered to her office by the end of the week. He informed her that the matter had been referred to the Attorney General's office and to the United States Attorney's office. He informed her that her IOLTA account would be frozen effective immediately under an emergency protective order. She stood up. She picked up the leather briefcase. She left the paper cup of coffee on the table. She did not speak again until she was in the parking lot, where a union leader photographer, tipped off by a source inside the disciplinary office, took the photograph that would appear on the front page of the paper's regional section 3 days later. In the photograph, she is walking toward her car with the briefcase in her right hand and her left hand shielding her face. The photographer's angle catches her wedding ring in the winter light. Behind her, through the 3rd floor window of the Attorney Discipline Office, a shape that might be Christian Wexler is visible standing at the window watching her go. Formal charges were filed in January of 2025. The New Hampshire indictment charged Priscilla Ann Vane with 11 counts of theft by misapplication of entrusted property under NHRSA 637.10, 1 count for each affected client. It charged 11 counts of conversion of client property under state common law. It charged 1 count of engaging in a pattern of professional misconduct. The federal indictment, filed in the District of New Hampshire 2 weeks later, charged 18 counts of wire fraud under 18 U.S.C. Section 1343, each corresponding to a specific fabricated communication sent to a client. It charged 1 count of aggravated identity theft, based on Vane's use of client signatures on certain settlement authorization documents that had been prepared after the fact to paper over the diversions. The total statutory maximum exposure across state and federal counts exceeded 120 years. Her defense attorney, a Manchester litigator named Robert Kessel, who specialized in white-collar defense, filed the standard early motions. Motion to dismiss for lack of specificity, denied. Motion to sever the federal counts from the state counts, denied. Motion for a change of venue based on pretrial publicity, denied. The New Hampshire Supreme Court, on emergency petition from the Attorney Discipline Office, suspended Priscilla Vane's law license on January 24, 2025. The suspension order noted that the evidence of misappropriation of client funds is not seriously in dispute, and that the ongoing threat to the public interest in the administration of justice requires immediate action. She surrendered her bar card by mail 2 days later. The Public Protection Fund began the process of reimbursing the 11 affected clients. Peggy Doiron received her $152,000 in early February of 2025, 16 months after her settlement had funded. She used a portion of it to catch up on the mortgage payments on her mother's house. She used another portion to resume the physical therapy that her insurance had partially declined. She did not, according to a brief interview she gave to a local paper, feel relieved. The money is not the point. The point is that she looked me in the eye and lied to me for 9 months. The money doesn't fix that. The other 10 clients were reimbursed by early April. The fund's disbursements totaled approximately $640,000. The fund, in turn, holds a lien against any assets Priscilla Vane may eventually be required to forfeit as part of restitution in the criminal case. As of the filing of this case, the criminal case is pending. Trial is set for the fall term of Halloway County Superior Court. The federal case is scheduled to trail the state proceedings. Kessel has signaled, in filings and in comments to the local press, that a negotiated resolution is being explored. The realistic sentencing exposure, based on comparable New Hampshire attorney misappropriation cases, is between 5 and 12 years in state prison, with restitution ordered in the full amount of the diverted funds, plus a permanent bar from the practice of law and a lifetime disqualification from any position of fiduciary responsibility. Her husband filed for divorce in March of 2025. The 5-bedroom colonial overlooking the Contoocook River Valley was listed with a Concord realtor in April. The boat at the marina on Lake Sunapee was sold. Her older son withdrew from the Concord Prep School and enrolled at the local public high school. Her daughter's competitive show circuit ended. The Vane Law Office sign, hand-painted on wood by a local craftsman in the summer of 2007, was taken down from the front of the hardware store building on Main Street in Halloway Falls, sometime in late January. The building's landlord donated it to the Halloway County Historical Society, where it sits in a storage room with other artifacts from local businesses that did not last. There is a specific weight to attorney misappropriation cases that other financial crime cases do not carry. Attorneys hold client funds because the profession, over centuries, built a regulatory architecture designed to make holding those funds safe. The rules exist because the profession understood the risk. Priscilla Vane knew the rules. She taught the rules. She served on the committee that enforced the rules. She sat through the continuing legal education seminars where the rules were explained to newer attorneys. She knew, from the first diversion, that what she was doing would end exactly the way it ended. She did it anyway. For 3 years, she did it anyway. The 11 clients whose settlements she diverted were exactly the people the IOLTA system was designed to protect. Injured, vulnerable, financially depleted by the events that had brought them to her office in the first place. Trusting a professional because the professional held a license from the state that said trust was warranted. Peggy Doiron kept the notebook, the one she filled with the shifting explanations at her kitchen table next to her landline, the one she took to the library on September 11th, 2024, the one she copied and mailed to the Attorney Discipline Office. It sits now in a filing cabinet in Nathan Trombley's office at the New Hampshire Department of Justice, marked as an exhibit in the pending prosecution of the state of New Hampshire versus Priscilla Ann Vane. This case was quiet in the way only white-collar cases can be quiet, but the case on the right-hand side is on a level all its own. Click it now.